Hi, folks. David Graff from Muller Graff. Today, we're going to talk about disproportionate assessments. Can you do it? Should you do it? When would you do it? And if you wanted to do it, what would you look for in your governing documents? It's important to remember that for many, many years, including to this day, the declarations of a community will set forth the association's assessing authority. The declarations also will typically, and they're required by statute for communities created after July 1 of 1992, will typically list the allocated interests. Doesn't mean that they do, and we've had a couple of opinions lately where we're trying to find out what the allocated interests are, or what the assessing authority is, what the board can and can't do to meet the funding requirements of their particular association. An allocated interest is just a share of the voting and assessment burden. So it's a voting right coupled with an assessment burden, and they don't have to be the same. And for a community that has disproportionate assessments, for example, a condominium community where a one-bedroom condo pays X percent of the assessments, two-bedroom pays more, three-bedroom pays yet more, sometimes the writers of those governing documents gave them equal voting weighted power, meaning a one bedroom has a certain weight, a two bedroom has a certain weight. And that's an absolute nightmare to administer from a board or management perspective at an election. It certainly can be done, and we've done it a number of times. But the point I'm trying to make is that usually it's one vote per unit or lot, and the assessments can be all over the place. And Kiowa just says that the allocated interests have to be set forth in the governing documents, and they can't discriminate in favor of the declarant, the person developing the community. But other than that, they're pretty durable, and they're supposed to be, because the law doesn't encourage and doesn't support the idea of a certain number of people coming in, changing the allocated interests where the members of the board pay zero assessments and everyone else pays twice as much, or the community gangs up on somebody and tries to make them pay more because of a perceived benefit that they're receiving. And we'll talk about that later. Generally, allocated interests are difficult to change. And they're difficult for that exact reason, is to prevent abuse by a majority vote or higher even, such that other people have to pay more, because the idea is that they bought in to the community with the understanding that they pay a certain percentage of the total assessment burden. So you can change them, but you have to look at your governing documents. And a lot of the documents created in the 70s and 80s will have, not a lot, but some will have a unanimous consent requirement, meaning that if the association wants to change the allocated interests of the various units, it can only do so with 100% approval by all of the owners. And that's obviously a very, very high burden to meet, almost impossible. Excuse me. And before you ask, the court petition process in 217.7 of Kiowa does not apply when the amendment is going to change the allocated interests. So we've got to be careful in changing the allocated interest. The law considers it an extraordinary act to do so. And in fact, the mandatory write down to 67% to amend a declaration, if the declaration had a higher percentage, is not applicable when one of the changes, when the association is changing the allocated interest. So very, very reluctant on the part of the law to allow these types of changes, and it's very hard to do. So just be aware of that. And the question is, should you change the allocated interest? Well, reluctantly, maybe. One of the questions we get, especially when the allocated interests were based on square footage of the units, was we found out the allocated interests were wrong because the square footage was measured incorrectly. So we want to change it to make it right. Great, right? We always want to have good data, and we want the documents to reflect as much as it can of reality. The problem, I think, is that when we change the allocated interest, even to improve it in terms of accuracy, we have to remember that it's also unfair at the same time to the owners who bought in and relied upon paying a specific share of the assessments. So, to me, the first thing we question is, well, is it so unfair that it overrides the unfairness of changing the allocated interests that have been in the covenants since the community was formed? Sometimes the answer is yes. Many times the answer is no. It just depends. So we don't recommend it lightly. And again, the law is designed by intention to make it very difficult to do. So when we're talking about the general assessing authority for most associations, for many, particularly those created from the early 70s until the mid 90s, the association levies a budget, right? It takes the budget and it apportions that by the allocated interests across all of the lots or units in the community. And that's what owners pay. That's why we refer to assessments as assessments rather than dues, right? You're not paying dues to a club. You can't just drop out of the club and not pay your dues. The assessment language is precise because it's your proportionate share of the obligation that you have to pay by virtue of you being an owner of an interest in that corporation. That is your assessment, your apportioned amount of the total annual budget. And there's a process. 3034 of Kiowa sets forth the budget process, and that was made applicable to pre-1992 communities mostly in 2018, I believe. And what they said essentially is that for a pre-1992 community, you still have to send out a summary of the budget and schedule a budget meeting and then have a meeting where you talk about the budget. And you don't have to have the homeowners veto it if the declaration sets forth a maximum assessment increase and you're within that maximum. Also, it's important to remember that the change to pre-1992 communities in Kiowa doesn't make it any easier for pre-92 communities to get their budget approved if it has a very high threshold or owner vote to get it approved. So it says basically, unless required by the governing documents, the owner's consent is not required and will be deemed to have been obtained in the absence of a veto of blah, 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 blah. So the statute really, created some administrative burden for communities, didn't help them out in streamlining the budgeting process when an assessment increase was required and they couldn't get the owner vote. And that just was not on the radar of the legislature then and is not now. So just be aware that generally we're talking about an annual budget. And if we're going to do something differently than assess somebody in accordance with the allocated interests, then we need a darn good reason. And that reason meaning something in the governing documents or state law that allows us to do that. And so that's the bulk of what we're going to talk about today is what do I look for? What do these things mean? And if I have them, how do I use them? So special assessments. Now, if the declaration does not provide for special assessment authority, you arguably can't do one as it's commonly referred to, meaning you can't just say the board voted and you have to pay special assessment of $2,000 per unit, for example. Don't have that authority. Now, what you could do, arguably, and you have to check the governing documents and talk to your lawyers, is to revise the budget midterm and revise it to show that special assessment. Follow the declaration process for the budget and see if the owners veto it, depending on whether they have to approve an assessment increase or not. There is no statutory reference for a special assessment, meaning you don't get the benefit of Kiowa to support a special assessment that is not permitted in your governing documents. Interestingly enough, Kiowa just doesn't deal with it. And I think the reason is that the presumption, my take, was that if the special assessment was set forth in the governing documents, then they could follow that. And if it wasn't, then the community could follow the budget ratification process in 3034 to levy that special assessment. So you don't get any bailout from the state statutes on this. And best case scenario, you can do it. Worst case scenario, owner vote or owner approval required, and you don't get any assistance from the law to bail you out of a difficult situation. So just know there's usually few assessing mechanisms in a declaration that is entirely intentional. We don't want ambiguity in terms of what people pay. When we're talking about what people pay, owners have to pay, we're serious as a heart attack in the law. And the law doesn't like that changed lightly. So you have to know what your documents say. So let's talk about some non-standard, non-annual budget assessment processes. And these are my terms. They can vary pretty significantly in the governing documents, but one of the ones that comes up is what we refer to as a special unit assessment. You can call it a benefited unit assessment or what have you. And the reason that comes up in conversation is because there's a section of Kiowa 315 that provides for this benefited unit assessment. And what it says, first of all, this section of 315, and I think all of 315, only applies to post-1992 communities. So if you're pre-1992 community, you can't take advantage of this statute. If you're a post-1992 community, what you have to really read it closely, you'll realize what it says is that to the extent required by the declaration, that's the preamble. So that means it has to be in the declaration and required. It goes on to say that if there's a common expense that benefits fewer than all of the units, the benefited units can be assessed for that common expense. So what the law is basically saying is we will follow or allow you to enforce the terms of your own governing documents, but we're not going to give you independent assessing authority to just tell certain people that benefit they have to pay this, whereas others may not have to. So this section 315 in Kiowa is pretty illusory in that it doesn't really give you any more rights than you would have already had on your declaration, because if it's not already required in your declaration, then you can't take advantage of the language in 315 of Kiowa. So special unit assessment would typically need to be called out specifically in the governing documents. Newer documents have it. And one of the questions is, what is that benefit? I mean, where does it end? I mean, does the person who's at the end of the private road have to pay more to use it than the people at the very beginning? And the idea and the concern, I think, is that we don't want to start dividing up all of the portions of the community that people don't have or equal access to and say, because of that, you have to pay more. It'd be an administrative nightmare. And it kind of turns the whole assessment argument on its head, which is the allocated interests are supposed to be set in stone through the declaration, and they're not to be changed lightly. And if the association through its board can just say, oh, well, you get that benefit, therefore you pay for this, you pay for that, you don't pay for this, we really have lost the bedrock of how we deal with assessments, which is with absolute certainty based on the language in the governing documents. So it's out there, just be careful. Oh, let me see here. I may have sent the wrong one to myself. Give me 1 second if you don't mind. Okay, and I'm back. Sorry for the delay there. So again, the special unit assessment, benefited unit assessment only applies to post-92 communities. And again, you have to have it in your declaration. Let's talk about a default assessment. Default assessment is sometimes defined as an assessment that's levied because the association has incurred a cost or an expense as a result of an owner's failure to comply with the governing documents. And we see that in newer governing documents, and we write it into newer governing documents in the event that an owner is in default of their commitments, and it causes the association a cost in terms of damage to the common area or what have you. You can go ahead and charge that to them. You have to be reasonably clear with that. One of the things that's at play here is that Kiowa's 123 says essentially in the event that there's a lawsuit, a dispute over the assessments or the governing documents, the prevailing party may seek reimbursement of their legal fees and costs as a result of that litigation. And so it's not until the court has said that we have a judgment for the legal fees and costs that we would assess them, consider them, that the owner clearly has to pay for them. This default assessment is a little bit of a shortcut around that, and I'm not sure if a court would uphold that if it was just for legal fees. If the homeowner, drove their car into the garage or a common area or the pool, and we had to pay to fix that, then I think that would be a good basis for doing so. But it has to be in the governing documents, and if it's not in the governing documents, then you can only deal with a default assessment through an argument that there's a negligence claim, meaning their negligence outside of what the governing documents provide their negligence caused the damage, therefore they have to pay the consequences of their negligence. And it's not a bad argument, but sometimes that butts up to the association's obligation to maintain insurance on something that they damaged. And if we have insurance on something that they damaged, there's a pretty darn good argument that the owner could make, and likely will make, that we had a duty to file the claim so that the owner who caused the damage can benefit from the proceeds of insurance for the insurance policy that they were paying for through their assessments. So be careful. And if you're rewriting your governing documents, you may put that on your wish list. Then there's the casualty or insured loss assessment. And what that says is, typically, if it's in the governing documents, in the event that the stuff, the components of the community that the association insures are damaged and the insurance proceeds are insufficient to repair them, then the deficiency will be, and in Kiowa it says, a common expense levied to the owners in accordance with their allocated interests. Now, the declaration can change that and say the uninsured portion is levied to the owners whose units were damaged in the relative proportion of damage and cost of repair, or it could be apportioned to the owner who caused the problem through their negligent act or omission. So it depends on the declaration language. And some governing documents, probably late 80s on, depending on who wrote them, may have a casualty assessment that does not require the vote of the owners. And the argument is, well, if the owners aren't going to vote to terminate the community, and the community needs to be restored, and the insurance proceeds are insufficient, well, then the owners don't really have a choice in whether or not they can pay to restore the community. They have to. Therefore, it's a mandatory assessment. So it just depends on the governing documents. Then there's the deductible assessment. And this sometimes would be done pursuant to an insurance deductible policy. Sometimes it would be done in the governing documents. It just depends. Language in 313 of Kiowa, which covers insurance, is only applicable to pre-1992 communities. So it's only applicable to post-92 communities. It is not applicable to pre-1992 communities. So when we have a pre-1992 community, the insurance provisions of 313 don't apply, but the governing documents obviously will, and they may deal with a deductible. And I'll just tell you, if you have a declaration now that says the deductible can't exceed, say, 10% of the face value of the policy, or $1,000, whichever is less, or even $10,000, you want to talk to your insurance agent to make sure that your insurance policy is in compliance with your governing documents. You don't want a $25,000 insurance deductible and a $10,000 requirement unless the association through its board is making the decision that it will cover the $15,000 spread out of its operating account. So we don't want to have insurance policies at variance with the requirements of our governing documents, because ultimately what we want to do, if we can, we have a deductible. We want to be able to levy that to the owners and give the owners a good, meaningful opportunity to get that covered under their own HO6 policies. And if we don't do that because we messed it up or we didn't follow our governing documents, there's a good chance that they will not have the ability to get that covered by their insurance carriers at the HO6 level. And then it will typically come from the association's operating account, because you're going to have a heck of a time getting an owner to pay a special assessment for an uninsured loss that was only uninsured because the association failed to follow the requirements of its governing documents in maintaining insurance. And D&O coverage might defend that lawsuit, and it might not, because some D&O policies, understandably, aren't intended to replicate coverage that should have been obtained through a different carrier. And then there's the damage assessment. And this can either be assessed because there's a provision in the governing documents, or I think even if there isn't one. If there is one in the governing documents, we have to follow it. And sometimes they require notice and an opportunity for a hearing. They might require special procedures, first mortgagee notification. But if there's nothing in the governing documents and the owner was negligent and it caused the association harm, then unless the governing documents say the association couldn't bring this type of case, the association could bring a case seeking reimbursement for the owner under a common law, non-declaration negligence claim. So kind of like living in America, you break it, you buy it. That's kind of what this is. So, we have to be careful of that. The problem, I think, is that negligence is in the eye of the beholder. And I'm about to talk about negligence, and you're going to think, oh my goodness, it's so vague and amorphous. How does anybody know what it is? Well, the reality is that it's the standard of care that is applied in every state in America. And if you are negligent in doing something, and if you hurt or damage someone else's interests, you have to pay for the consequences of your negligence. And courts in every state, every day, figure out what negligence is. It's a very fact-intensive dispute, but generally, it's the existence of a legal duty, a breach of that duty, causation, meaning the breach of the duty caused the damages, and then the fourth is that there are damages. And if those things are proven, then there is negligence. And we spend a lot of time over the years telling boards or advising boards on what negligence is. Can they go after the owner for that? Do they not have the ability to? And I'll just say that there's often a disparity in opinions in terms of what negligence is. It is not merely the consequence of something bad happening. It is something bad happening as a result of somebody not giving reasonable care to a duty that they had. And so just because someone's toilet leaked or shower leaked or pipe broke doesn't mean that they were negligent. And if we're looking at a negligence analysis, you have to prove that deviation from the standard of care that was required. And if you can't prove that, and all you can point to is, well, the thing leaked, you're going to lose. So much caution to be given when determining what negligence is. And ultimately, only a judge or a jury can decide that. We can give you some good ideas of what we think it is, but it's often not going to be negligent just because something bad happened. Now, we can change that fact. As an example, if we know that the community has water heaters that are 20 plus years old and very few people have changed them out, we could send them a notice, multiple notices that say, hey, change out your water heater. If you don't, it's going to leak, and we may seek the uninsured portion of the loss from you. And what you're doing by this is creating, not only you're creating knowledge on their part, knowledge that there's a problem. And with that knowledge and their unreasonable failure to respond or to react accordingly, you've created a possibility that an owner could be negligent where they wouldn't otherwise have been. So something to think about when we have water heaters or supply hoses or things like that, educating owners about what they need to do and what can happen if they don't do that. Not only does it get compliance, but it also sets you up for a negligence claim. One of the things that we fight about or we talk to boards about is this non-negligent assessment of damage. And it could be, hey, we want to charge every pet owner a $200 non-refundable fee, may not even be a deposit, or we want to charge everyone who smokes in their unit or everyone that rents their unit an extra $500 because they cost us money. Very hard to do. Now, because if you look at it in the eyes of the law, you're essentially making stuff up. And again, when you take the proposition that allocated interests telling an owner what their share in the common expense burden is are almost set in stone, this type of non-negligent assessment is going to be very hard to fly. It can work, and I'll talk a little bit about when it can work, but you have to be careful of that, because when we're talking about non-negligence, either their standard of care was not unreasonable or the thing that we're worried about hasn't happened yet. So if we said last year we had dog damage to the common elements and we have dog owners, so because of the cost, we're going to assess every dog owner a $500 assessment. Well, it's hard to do that in advance of the thing being damaged. Courts don't like us doing that because, again, that looks like we're making stuff up. If we're doing it after the fact, then we can say, well, this is what happened. We have the damage. We have an expert giving us the damage repair figures. Then that's a heck of a lot better. But even so, that's a unit owner specific issue, which is if the damage was caused by dogs, which dogs? Not every dog owner in that community is going to be responsible for the damage unless we can prove it was their dog that damaged it. Now, we could amend the governing documents to say you have to pay, all pet owners have to pay $50 or $500 assessment, or every renter has to pay this. And that's much more likely to be upheld if it gets disputed. So think about that. One of the ones is a move-in fee. Now, if it's some service that we provide as an association, maybe we have an owner orientation, we lock off the elevator, we put up the blankets, we do certain other things, we make the loading dock available, we might be able to argue that a move-in fee is reasonable because of the services that are provided. It's not because these people are negligent or we're worried about them being negligent. It's because we're giving them the benefit of something that they wouldn't otherwise have. We just have to be careful in telling owners, okay, we as the board have decided that it's renters who are causing all our problems. So we're going to make it very burdensome for the landlord owners to rent. And we're going to create a move-in fee and a move-in fee movie for owner orientation that you have to pay for to watch. And you have to pay for the management team to sit there in the lobby and watch it with you and so forth. It gets very tenuous to defend those. And if you go in front of a judge, you're probably going to lose. But again, it's going to depend on what it is, how we adopted it, whether in policy or a rule, same thing, or a declaration amendment, and to what degree can we prove the harm that we're alleging they have to pay for. And if the harm hasn't occurred yet, it's very, very difficult. So language of your documents is critical. I think that's it. I think I've covered all the assessments. So the moral of the story is that we have a common assessment that is broken up and distributed among all of the owners according to their allocated interests. Allocated interests can be changed, but it's very delicate to do, and it's to be done with extreme caution. There's a number of other assessment possibilities in governing documents. There isn't any independent statutory authority for those types of assessments. There is the possibility that we recover an uninsured loss if an owner was negligent, but we have to be very careful in being able to prove negligence. And if we can't prove negligence, then that's a common expense of the association. So we got to be careful, and we want to have our governing documents be reasonably clear in terms of what people have to pay. We do want to reserve a little bit of latitude to deal with default situations and possibly benefited unit situations if we can articulate a significant benefit that fewer than all of the units are receiving. If it's just, length of feet in a road or something else that's not really, in my opinion, very compelling, it's not necessarily going to be enough to claim benefited unit and support an assessment against those benefited units if the benefit is not clear enough. So I'll turn this off, take any questions, and appreciate you being here. Thanks again.